Good afternoon. My name's Matt Fryar, and I'm a partner with the law firm of Crouch, Harwell, Fryar, and Ferner in Springdale, Arkansas. In our last couple of videos, we discussed some fundamentals of estate planning. What is probate, and why you don't want to have to go through it? What is a beneficiary designation, and how it can help you avoid probate? Some of the most common questions I get from my estate planning clients are, what is a will? What does a will do? Do I need a will? So I'm going to use this video to answer some of those questions. First of all, a will is a legal document that allows you to choose who gets your probate assets when you pass away, who's in charge of your probate, and who is going to raise your kids if they're still little when you die. So let's take those one at a time. First of all, who gets your probate assets? That alone should indicate to you that a will is only necessary if you have a probate. If everything you own is passing by joint ownership and beneficiary designation and trust, then hopefully your will is perfectly useless. That's a good thing. You don't want to have to use your will, because if your will's in play, that means you're going through probate. But it does let you say, if I have probate assets, this is who is to get them. It also lets you say, who's going to be in charge of my probate? A lot of you have heard the word executor. That's what we're talking about. Who is my executor going to be? Who is going to be the point person in my probate? Who's going to file the paperwork with the judge? Who's going to go see the judge if we have to have a hearing? Who's going to deal with the lawyer? Who is my executor? And third, if my kids are still little, who's going to raise them? Who do I want my kids to live with? Who do I want to be responsible for taking care of my kids until they become adults? And so that's what a will is. What a will does, we've talked about a little bit, but more importantly, I want to explain what a will doesn't do. A will, by itself, at least in Arkansas, does not avoid probate. That's a common misbelief. People think, if I have a will, I've avoided probate. Not in Arkansas, you haven't. So a will, like we've said, is a roadmap for your probate. It tells the executor, it tells the judge, it tells the heirs, here is the end goal. Here's what we're trying to accomplish with this probate. But a will does not, by itself, avoid probate. Do you need a will? Absolutely. Almost everybody needs a will. Almost everybody runs the risk of leaving behind a probate estate. Even the best laid plans, somebody who is diligent in putting beneficiary designations on everything, somebody who has a trust and has done some more advanced estate planning, that person can accidentally leave behind a probate asset or two. Maybe it's a bank account and a vehicle. Maybe it's an investment account that, oh man, I could have sworn I had a beneficiary designation on that. Well, you didn't, so now it's going through probate. You need to have a will to back that up and make sure that you've left instructions for what's going to happen when that probate's over. So, we've talked about what a will is, we've talked about what a will does and what it doesn't do, and we've talked about the fact that everybody needs a will. But in future videos, we're going to talk about what else you might need, because a will doesn't avoid probate by itself. So you and your family may be in a position where you need to do some more advanced estate planning and incorporate some other tools like a trust into your estate plan. Stay tuned, and we'll talk about those things soon. Have a good evening.